No transactions lawyer or dealer should miss this podcast. Welcome to the Solution Nation podcast. My name is Sean Snowday, and I'm the president of Solution Nation. Solution Nation is dedicated to providing a platform for investors to learn about Israel's most dynamic public and private companies. We interview lead venture capitalists, Wall Street analysts, investment bankers, and managers of incubators and accelerators. Today's guest is Professor Zohar Goshen. As the Jerome L. Greene Professor of Transactional Law and Director of the Center for Israeli Legal Studies at Columbia Law School, Professor Goshen's articles on corporate law and securities regulation are frequently named among the top 10 best articles of the year by Corporate Practice Commentator. The proposed and disputed Musk Twitter transaction is perhaps the most eventful and contentious acquisition in modern times. Fortunately, one of the brightest legal minds dissects the terms, twists and turns, and possible outcomes of this gripping saga. Professor Goshen speaks about Twitter's poison pill and fiduciary duties, as well as the use of breakup fees, hell or high water provisions, performance clauses, waiving of financial contingencies, and irreparable harm. On this podcast, we tackle contentious issues, such as why Twitter might allow Mr. Musk to disparage Twitter on Twitter, and what the consequences of such disparagement might be to Mr. Musk. We discussed whether the Musk team erred in waiving normal due diligence opportunities and in not hedging against the risk of Twitter's shares falling unexpectedly. On this podcast, sparks really flew when we got to issues of Twitter's reporting of the incidents of bots on its platform. How can bots be detected and counted? Are Twitter's representations of the incidents of bots credible? If not, is the difference material? If the incidence of bots is much higher than Twitter reported, can such lapse trigger a material adverse event? Would that development extricate Mr. Musk from the deal? No transactions lawyer or dealer should miss this podcast. Please remember that all content provided on the Solution Nation podcast and website is for educational purposes only. Nothing shall be construed as investment advice. Investment decisions shall not be made based on information, written, verbal, or otherwise, posted or spoken on Solution Nation. Conduct your own research or consult with your own investment advisors before making investment decisions. So here's my good friend, the host of the show and the CEO of Solution Nation, David Wanatik.
Welcome, everyone, to Solution Nation. I'm David Wanatik. Today, we're going to talk about the potential acquisition of Twitter by Elon Musk. This is a very interesting topic. Very pleased to introduce our speaker. Our speaker is Professor Zohar Goshen. Professor Zohar Goshen is the Jerome L. Greene Professor of Transactional Law and the Director for the Center for Israeli Legal Studies at Columbia Law School. Professor Goshen teaches and writes about corporate law and governance, securities regulation, and corporate finance. His articles on corporate law and securities regulation are frequently named among the top 10 best articles of the year by Corporate Practice Commentator. Most recently in 2019 for The Death of Corporate Law, in 2017 for Principal Costs, a new theory for corporate law and governance, and in 2016 for Corporate Control and Idiosyncratic Vision. There were co-authors of those papers as well. Professor Goshen was awarded the Willis L. M. Reese Teaching Prize in 2019 and 2006. He's only the third repeat winner of the award, which is given annually by the graduating class. So, Professor Goshen, thank you very much for speaking to us today.
Thank you for having me.
Great. Well, so the proposed acquisition of Twitter by Elon Musk, this seems just to be a regular transaction, right? Nothing out of the ordinary.
Yeah, it started a bit out of the ordinary, the way Elon Musk got into this transaction was not in the normal courtesy approach to the corporation. Everything was over Twitter. One morning they wake up and they discover that he owns more than 9% of the shares and he's the largest shareholder of the corporation. The second day they offer him to join the board and he says yes. And when they approve it, the following day they say, oh no, I'm not going to go on the board, I'm going to buy the corporation. And then he makes an offer, which is take it or leave it, $54.20. And the whole thing, it didn't happen in normal course you would buy a corporation.
Okay. So yes, initially he started acquiring shares, and he didn't disclose his acquisition of the shares to the SEC. He was supposed to report once he accumulated more than, was it 5%? He was supposed to.
Yeah. According to the US law, once you reach a block of 5%, then you have 10 days in which you can keep buying shares, but at the end of the 10 days, you have to disclose that you are owning those shares. And obviously it didn't follow with that. You know, there are some arguments how you can't count the 10 days, but given the most normal routine interpretation of those 10 days, he didn't follow the law on the disclosure timing.
Well, what kind of penalties can there be for failing to disclose the accumulation of 5% of the stock?
This is part of the limitation of securities regulation as far as disclosure is concerned. The amount of sanctions that you can impose on this type of violation is monetary, but for a person who's the richest person in the world, it's not really something which creates any deterrence.
Okay. And shortly after Mr. Musk started acquiring Twitter shares, Twitter implemented a poison pill, correct?
Yes.
What form was the poison pill in?
So a poison pill is something you insert into the bylaws of the corporation, which basically says we set a threshold, normally about 15%. And if you are going to cross that threshold without the board approval, then what's going to happen, we are going to issue to all other shareholders rights to buy additional shares at half the price, which the result of which would be major economic dilution of the ownership value of the person who crossed the threshold. So it's a very effective tool to prevent someone buying more and more shares without paying premium when they want to get control.
Mm-hmm. Okay. And do you know to what extent the existing shareholders purchased those shares at a big discount?
No, he never triggered the poison pill.
He never did. Okay.
Yeah, he stopped at the 9 point something percent, and that's it.
Okay.
So no one normally with a clear head would cross the threshold because it's very, very expensive.
Right. Okay. So the poison pill was never implemented.
No, it was implemented, but it
wasn't triggered.
It did what it needs to do, which is to stop Elon Musk from buying more shares.
Okay. Anyway, Elon Musk acquired shares, and he made an offer, $54.20 per share, and the board thought that was a very rich price. They didn't see anybody else that would bid more than that. Did they make a concerted effort to seek another buyer or to have some kind of auction?
They employed several investment banks to help them in that process, and they did the search process at that time. It was not a formal public auction, but behind the scenes exploration by the investment bankers. And the investment bankers came back and they provided the board with what they call fairness opinion, meaning some valuation that they did, basically telling the board that's a good price.
Okay. And so shortly after Elon Musk made the offer and Twitter hired the investment banks to see if there were any other opportunities to receive a similar or higher price, and that didn't happen. They couldn't find another buyer. Elon Musk wanted to back out of the deal. Maybe it was because of Tesla's stock declining in value. He lost maybe $100 million of value.
Billion.
100 billion, right. Okay. the financing he put in place, that still stayed in place. Is that correct, more or less?
Yes, the financing is in place. In fact, he offered what he called seller-friendly contract to facilitate the acquisition of Twitter to persuade the board to sell Twitter. And in that contract, what he did, he gave up first on due diligence process, and second, on what is normal in many of these contracts, which is financing condition. He took out financing conditions. So basically, the financing that he arranged is already done.
Mm-hmm. Okay. What would happen if the financing fell through, if the financing didn't come through for whatever reason, if the banks and other investors just decided not to go through with this? Would that trigger the breakup fee?
No, not in this case.
Okay.
Because normally in a normal contract, when you have a financing condition and the financing doesn't go through, then the breakup fee, the reverse breakup fee will take place. Okay, you pay whatever penalty you need to pay and you go away. In this case, it's not, since he gave up on the financing condition, he cannot walk away and just pay the $1 billion termination fee because the financing failed. For two reasons. One, the financing still, the letter that the bankers gave is a very unqualified letter. So it's still there and it will stand there until sometimes in, I think, the first quarter of 2023. So the letter is still there. The second thing, even the financing doesn't go through, he will have to put up the money because he gave up on the financing condition.
Okay. Okay. So that's not a possible way out for Elon Musk. Even if, for whatever reason, if the capital markets freeze up, or it is determined that far more than 5% of the monetary daily active users are bots, far more than the 5%. If that scares away the outside financing, the external financing sources, Elon Musk is still on the hook to go through with the acquisition.
Yeah.
Okay. All right. What situations would trigger Elon Musk paying the breakup fee rather than being forced to acquire Twitter?
So Elon Musk is trying to get out of the deal, not because of financing. His lawyer, in the letter that he sent about a week ago, on the 8th of July, is mentioning three different reasons why they think they are allowed to step out of the deal. In any case, for your question, the breakup fee, the reverse breakup fee, the $1 billion, is not conditional on financing, and it will be triggered, for example, if you request something from a regulator, and the regulator say no, you are not allowed to buy the corporation. In this case, since it's not in your hand, you can go out of the deal and you can pay the $1 billion termination fee. But these are the type of circumstances in which you will be able to exit and pay the breakup fee. But as far as Twitter is concerned, in the contract, they have a right for specific performance, which he agreed that they are allowed to pursue. It is their choice whether to let him go and ask for $1 billion or to go with specific performance. Given that they don't think that $1 billion is a sufficient compensation for what have happened, they are not pursuing this route, they are pursuing the specific performance.
Okay. What about the fiduciary duty that the Twitter board has? How broad is it? Is the fiduciary duty only to the shareholders, or is it a little bit broader than that? Is it to the employees or other stakeholders?
So according to Delaware law, when you sell the corporation, you have fiduciary duties only to the shareholders. There are no fiduciary duties to creditors, to employees, or to other stakeholders in the corporation. It's a straightforward rule in Delaware.
Okay. Do the shareholders include employees that own shares, or that employees may have shares vested to them or may have options? Are they included in the definition of shareholders?
Of course, but only in their capacity as shareholders.
Okay. So Twitter is basically saying that Elon Musk is misbehaving, maybe has bad character. They're saying negative things about him, or at least that's the tone of narrative that is coming out of Twitter. So could it be argued that the board of Twitter is breaching their fiduciary duty by trying to put the company in the hands of somebody who is damaging the value of the company, when the employees that have stock and options, invested stock coming to them, that the value logically should decline if the owner of the company is a bad person damaging the value of Twitter? So if I work there and I have shares, after the deal goes through, logic would be that the value of my shares would fall. So is the responsibility of the board to the shareholders only up to the date of the transaction, or are they supposed to look a little bit forward and try to predict how the employee shareholders will fare if a unfit person owns the company?
So you have to balance what you just said with the fact that Twitter was very quiet until the letter of termination came out. Up to that point, most of the disbursement of the corporation and came from Elon Musk. Elon Musk publicly accuses the Twitter with major fraud going on for several years. He asked the SEC to open an investigation about this fraud. So Twitter board was very quiet. They didn't say anything about Elon Musk. Only when he sent that letter that they started explaining the way he is behaving. So that's one thing that you should put into context. Second thing, the duty that you have is about the point in which you sell the corporation, and the shareholders, any employee who owns shares will get the money for those shares in the acquisition. They will get $54 if this goes through, which is from their perspective huge. As far as what's going to happen next, I know that many people sort of fear that he's going to destroy Twitter. I don't see that happening. The reason that I estimate he doesn't want to buy it is because now it becomes very expensive for him to purchase it, in terms of the amount of shares he needs to liquidate in Tesla, in terms of the amount of equity he needs to bring in terms of the cost of the financing. It became a very expensive deal. So if he has to buy it and he gets that, even a billionaire like him will not be able to simply destroy the value of the corporation. It will make his financial situation much worse. And take into account, he's not alone in this. He persuaded several other reputable people to come and own equity together with him in this corporation. He cannot wake up just one morning and say, oh, you know what, I'm going to close this corporation down. It's not going to happen. As colorful as he is not a crazy person. He understands that this is $44 billion corporation. You don't destroy such a corporation just to spite.
Mm-hmm. But the argument, Twitter is saying that Elon Musk's disparagement of Twitter has led to a depreciation of value. It may be demoralizing employees. It may be scaring away advertisers. It may thwart users from using Twitter. If they think that's true, most of the so-called disparagement from Elon Musk is going through Twitter. So why don't they just block him like they block so many other people, including the president of the United States? Tens or hundreds of thousands of people that don't agree with Twitter get blocked all the time. So it's like if a bank says that Elon Musk is committing wire fraud, and every day the bank goes along with the wire fraud, it seems contradictory to allow that to happen on their own platform.
So it's a very sensitive situation to block Elon Musk as the potential buyer of the corporation. It could have many ramifications in terms of what's going on, which is the litigation now, if that would happen. In terms of the effectiveness of that, Elon Musk has so many ways to communicate whatever disparagement he wants to communicate, regardless of Twitter. I can assure you, any TV channel that he would like to make an interview, everyone will say yes. So it's not complex for him to convey the message. The message will get out. Just blocking him on Twitter would just create complexities for what Twitter estimated will happen, which is future litigation. So you don't do that.
Mm-hmm. Well, just to the last point, Twitter is an effective tool for Elon Musk. It's one way. So he sends a message out. He's not interviewed, so nobody contradicts him or challenges him when he makes a statement. He has a huge number of followers, maybe 100 million, maybe one of the biggest. And he can send that out whenever he wants. When getting interviewed by a TV station or something takes time, and you don't get it instantaneously, even if you're Elon Musk. So Twitter is an important platform for Elon Musk to communicate. It'd be less effective without it.
I don't share that. It's just my experience from this last week when the deal fell. He announced the termination. It's like the amount of interest from TVs, newspapers, from all over the world that I got on my emails. It was like unbelievable. And I'm just a simple professor from Columbia Law School. So that's my sense is that there is no way that he would like to convey his message, and you can block that message because you blocked his Twitter account. Mm-hmm.
What would the lawsuit be? Twitter blocks people all the time, including the president of the United States. They must say that Elon Musk agreed to the rules when he became a member of Twitter. And, if they believe that Elon Musk is violating those rules, where's the lawsuit?
So the lawsuit is not about the rules of Twitter. The lawsuit is about signaling to the world and signaling to the court that you don't like that acquisition and you're trying to shut it down. He says that you have much higher board, that you're engaging fraud, and what you are doing, you're shutting him down. So how that signals to the market, how that signal to the court that you are trying to shut such a claim? And basically what they say, no, you can say it, and we say it's not true.
Uh-huh. Okay. What is the issue with irreparable harm? What could be an instance of Elon Musk committing irreparable harm against Twitter?
So Twitter is suffering on many dimensions. They are suffering because of the reputation damage with advertisers. They are suffering because of many employees leaving the corporation. Some of them are important. In fact, they wanted to have some program to keep crucial employees in the company, and Elon Musk, it's in the complaint, did not provide the required consent to do that, which makes more employees leave the company without being able to keep them in. So all of these aspects of that, especially when you remember, Elon Musk said that he has 3 options. One is to be on the board, one is to acquire Twitter, and one, people don't remember that, is to create a competing company. Okay, so when you take all that into account, this could be very damaging for Twitter.
Okay, so an instance of irreparable harm would be if Elon Musk does not go through with the acquisition, learns a lot through his due diligence and a lot of privileged disclosure, and he takes that proprietary knowledge and information and starts his own company or joins with Trump's company or something like that.
Something like that, but even if he doesn't do that, the loss of very talented employees for Twitter, it's going to be very hard to get that back. And that's also, and some of the advertisers, they might walk away and never come back. They find a different platform to advertise. And that's going to be damaging to Twitter as well.
But if it is determined that the bot ratio is much higher than 5%, that would be damaging, but that would be damaging because of Twitter's misstatements, not because of Elon Musk pointing out a fact, if that is proven.
Yeah, so I don't think this would be ever proven because you have to understand there is something very important in the way the discussion about the bots is taking place. Twitter never said we have 5% bots on our platform. Never. They did say we estimate we have 5% bots out of the monetized daily active users, which is a different calculation. What does it mean? It means that let's say they have 100 accounts. Every day they clean about 1 million bots. So every account that they already know it's a bot, it's out of the calculation. Okay, so let's say out of the 100, they found 30, clean them up. Now, when they go to advertise to the client that needs to advertise, they don't say we have 100 accounts. We say we have 70 accounts, but we estimate we might not found all the bots within the 70. So we estimate that number there to be about 5%. And we have a method to estimate that. But any account that we knowingly discover that one is a bot, we never calculate. So when they say 5%, it's 5% of after they already cleaned the platform from the bots that they have found, and they have a routine process to do that, about 1 million every day that they clean out. So that's one thing. The second thing is that the 5%, it's not a method which has any accounting methods for it. Okay, it's estimate, and they honestly say it's our estimate. It's based on some routine that we are using. Some other person might reach a different number than 5%, maybe higher. But we're telling you what we are doing, and according to what we are doing, it's 5%. That's the estimate that we have. So it's so qualified. How can you say it's fraud? That's the second. The third thing, even if there is a misstatement there, the misstatement is qualified in the contract by the requirement that it should be material adverse effect, meaning the misstatement should be so huge that it will have a dramatic effect on the value of Twitter. And I don't think anyone in the world thinks that the bot story is such a story that would create such a major effect on Twitter. So that's another point. And the fifth point, which is based on the fact that he gave up on the due diligence, which he now wants to do before closing, but he gave up on it. And remember, the reason he provided why he wants to take Twitter private is because he said it will be hard to fight the bots as a public company. Okay? He basically says in one of his tweets, we will try or die trying. We will fix it or we will die trying to fix the bot problem. So he knew about that. There is nothing new there.
I would like to present some other ideas with the issue of bots. But first, let me go back to the issue of irreparable harm for a minute. If irreparable harm takes place, could the damages be greater than the acquisition price, the 44 billion plus the 1 billion breakup fee, could the damages be higher than the sum of those two numbers?
First, you cannot get both the 44 billion and the 1 billion. Okay. The second thing, there are never going to be a case in which you will have damages which are more than $44 billion. If he bought the corporation for the price he agreed, then whatever damage there is, it will fall on him.
Okay.
As far as the $1 billion, even if you are suing for damages, then in the contract, it's specified that damages are capped at 1 billion. Therefore, they are not suing for damages because damages are capped at 1 billion.
Okay, so irreparable harm is tucked into that $1 billion reverse breakup fee.
If they would sue for damages, but they are not doing that. Yeah.
Okay. Before I get to the bot issue, can you explain hell or high water clauses and do they apply here?
So these clauses basically mean, in simple language, you must do it. And in this case, it is relevant to the financing condition, meaning he gave up on the financing condition, meaning he must do it. He must find the financing, and if he doesn't find the financing, he has to bring the money. That's what it means.
Okay. All right, so just on the issue of bots again, because this is a very serious issue. It's one of the main themes of Elon Musk efforts trying to withdraw from this proposed transaction. Every media company, when it comes to selling to advertisers, has an incentive to spin the number of viewers, readers, subscribers, right? I mean, everybody has an incentive to present a highest number possible. And that's even from ethical companies. Twitter, I think we could argue is not an ethical company. It interfered in a presidential election when Hunter Biden's laptop computer arose. Before the Biden campaign, before the Democrat Party said that this is a Russian hoax, Twitter said that before anybody said that, and then they blocked the New York Post. So that's one issue. You have this new CEO going on record saying he doesn't really uphold the First Amendment, and for Americans, that's shocking, especially someone in the media industry. Twitter has declared, it was declared in April, Twitter said that it had overstated its user base for nearly 3 years through the end of 2021 because of an error in how it accounted for people linked to multiple accounts. The revision reduced the number of monetizable daily active users by 0.9% for the fourth quarter of 2021. So that's almost 1%. 1% of 5% is 20%, right? So that's a 20% error that they admitted. Twitter itself has said it's very difficult to determine what a bot is. Sometimes real people act like bots, and sometimes bots act like real people. I have a statement on my other monitor from SparkToro, a company that assesses things like digital users. They believe 49.3% of the accounts following President Biden are not real people. I know they might not be included as monetizable people, but that's a big number. And if it is demonstrated that there is an exaggeration in the bots, that could present problems with the SEC. They were misleading the SEC. Advertisers will flee. People might flee the site. It could cause serious financial damage to Twitter if Elon Musk is close to being right. So, with your permission, I want to leave the political agenda of Twitter aside. This is not my area of expertise. I have my own views about politics and about free speech and all of that, but that's not my area of expertise, so I'm not going to touch on that with your permission. I want to focus only on the legal issues, which is the topic that I feel I know best and I can express an expert opinion.
in every measurement that companies make, including for accounting purposes, you have some estimates all the time. And it is a normal thing to find along the way, after you make audit, after you make controls or whatever, that you might did something wrong and you didn't count it right, and you have to fix it. This has no malice in it. This is like a routine life. Many corporations restate their financial reports. And remember, financial reports are subject to GAAP. So they have rules, they have controls, and nonetheless, even after all of that, some of them restate their financial statement, basically saying, we're sorry, we made a mistake, we find a mistake, and we correct that. So the same is true even for non-GAAP disclosure, which is the number of boats, which is something that they estimate, and in the complaint that they disclose a bit about how they do that. They basically sample about 9,000 accounts every quarter, not 100 as he tweeted. And the process is alongside an automatic process that try to find the boats. And this process is in a way also manual. They go one by one and they try to figure out if it's a boat or not. So they have this process that they are trying to find out and give you the true picture. If they make a mistake and they correct it, and it's like the mistake is like very tiny mistake. So let's say it's not 5%, it's 6%. So what? It's not going to be a material adverse effect on the corporation. It's going to signal, in fact, credibility. We find a mistake, we fix it.
Well, 1%, 0.9% that they admitted, that is almost a 20% difference than what they are reporting.
Okay, so it's not 5, it's not 5, it's 6. Okay, let's add it. Instead of 5, let's say 6. So what? Is that different?
Well, yeah, it is 20%. It is 20% different. If a company misses its earnings expectations by 20%, the stock gets punished. That's one issue. And who knows what the real number is. In the Twitter's SEC filings, they basically said what you're saying, we do our best, but they didn't cite outside authorities that have audited it. They didn't explain their standards. It basically said, we do the best we can. And admittedly, it's very, very hard. You know, I don't know that anybody would know if any particular user or tweet is real. You know, even if you're a professional in this field, it's very, very difficult to determine what's a real person, what's a bot. When you're looking at billions of tweets a day, it's very, very difficult. But the stock market seems to think that there's a problem. On CNBC today, somebody did an analysis and they said, if you look at the price paid for Facebook's monetizable daily users compared to Twitter's reported monetizable daily average users, Twitter is trading at a 60% discount. So, you know, I think in psychology, there's an error of something called like framing error. That, you know, if I say it's 5%, people normally think, well, okay, maybe it's 6 or 7%, not 40%. But we don't know. We don't know if it is something like 40%.
And how is that relevant to Elon Musk?
Well,
let's go with your thesis. How is that relevant to Elon Musk, who knew from the beginning what's the condition with the boat, who gave up on due diligence? How is that relevant to the closing of the deal?
Well, you know, you're buying a media company that makes its money from selling advertising, which is a function of the human viewers that will consume that advertising. And if there's a significantly less number, then it stands to reason he should pay less. Okay, maybe a solution. What about a solution for this? Or everyone's inability to know for sure what the rate of bots is. Why don't they just have a big escrow? You know, why don't they just have a huge escrow, a couple $2 billion? And if there are lawsuits from shareholders, if the advertisers want refunds, can you pay out of an escrow? Would something like that work?
I really don't understand this line of questioning. And let's say you want to buy a house. The seller is telling you, take it as it is. That's it. You want to buy it? You say, yeah, I want it as it is. I don't want an inspection. I want nothing. Okay? You sign the contract and you say, oh, I don't have the money to buy it. So maybe they have termites there. I want to put some of the money out because if I discover that there are termites there, I want to take the money back. But you bought it as is. You agreed to it. What is that? What's the whole process now? How is that relevant to the buy?
If somebody deceives the SEC, could that be a material adverse event? Is that included?
So it depends. If you deceive the SEC over a fact that will be substantial to the valuation of the corporation, something very dramatic, then you can walk out. But I don't believe anyone think that this is the case with the 5% bots. Because as I explained, it's not 5% of all the users, it's 5% of the monetized daily active users, which is a different measurement. And if you read their disclosure, is very, very qualified. So how can you say it's fraud? They say this is our measure. Someone can come up with a different number. It could be more than 5%. This is what we found according to our system. You want to trust, trust. You don't want to trust, make your own guess. But they never say something that it's easy to say, oh, you said 1, it's easy to show it's 2.
Mm-hmm. Was it a mistake that callers were not used on the acquisition price, or were callers used on the acquisition price?
What do you mean by that?
For Elon Musk to say that depending on the price of the stock, I'll pay within a range. So.
Oh, you mean about having options? You mean? Well, it depends on the buyer and how they want to hedge the changes in market fluctuations. But in the contract, Elon Musk took upon himself the risk of market changes. He could have hedged that in any way that he wanted. No one prevented him from doing it. It was not the duty of Twitter, because Twitter in the contract passed that risk to him and he knowingly signed and accepted. So whatever protection to hedge that risk he could have used, it's too late now.
Yeah, it seems like that was a mistake.
Looking backwards, I have so many mistakes that I've done.
But this is a $44 billion mistake.
Yeah, I know. I understand. It's if someone would have knew that the market would crash with like 30%, the Nasdaq with the triple Q will go by 30%, we would have bought put options all day long, regardless of this deal.
Yeah, maybe Elon Musk was in front of his bankers. Maybe he was moving so fast he didn't take their advice. But somebody, I think, should have suggested that he tried to put callers on that offering price.
Well, looking backward, that would have been an excellent solution for the risk that he assumed, but I have no knowledge what was the internal discussions there. I don't want to speculate on that. But as I told you, looking backwards, many people are very smart.
Yeah. Well, okay. Yeah, an investment banker should have advised him that maybe they tried to, and maybe Elon Musk didn't pay attention. So anyway, I know it's hard. We can't look backwards. What about looking forwards? Do you think this is going to be a delayed trial, or do you think the trial will stay on schedule?
So there is a decision that was made yesterday. Twitter asked for expedited litigation. Elon Musk asked to delay it. The court accepted Twitter's position. There's going to be 5 days trial in October, and we'll get a decision fairly fast.
Okay, so that's going to happen. It's not appealable. There's nothing Elon Musk can do.
No, that's it. That's done. Yeah.
Okay, so we'll know in October what's going on.
October, we'll have 5 days of trial, and we'll know the decision fairly fast after that.
Okay. What do you think is going to happen?
I don't see, from my estimate of his arguments, I see the upper hand with Twitter. I see only two options from my perspective. One option is that he's going to buy it, but not for $54, maybe 50. I put, 30% chance on that. And the second option that I see is that they will get a settlement in which he's paying, instead of $1 billion, somewhere between $5 and $10 billion, and walks away. I put 70% on this option, and that's it.
Is there a possibility they could negotiate a deal before the trial? They could do that, right? So
it's not, that's what normally happens. Normally that you would settle before.
Yeah. So maybe Elon Musk, if he can come up with enough of an argument, maybe not necessarily to win, but to make it appear that he has a reasonable shot at winning, then you maybe do a probabilistic analysis. Maybe it's better to be 80% certain that you'll get 80% of what you want. So Twitter may decide to compromise it, like you say, maybe $46 a share or something like that.
I told you, I don't know what coming down from 54 to 50, it's a major compromise. And letting him go and accepting $5 billion, it's also a huge compromise from Twitter. But that's my estimate, something between 5 and 10, and he walks away, or he pays something around $50 and he gets the company. I'm not a prophet. I'm just giving you my professional estimates about what I think could happen in this case.
Right. Well, maybe I'll just leave on two funny notes. One commentator said that Elon Musk himself is the material adverse event. And then somebody else said that the biggest asset that Twitter has is this lawsuit.
Well, I certainly agree that if there was no solid claim for Twitter to go after Elon Musk to compel him to buy it for $54, that there was a substantial probability that it will not be trading at $38.
Yeah.
That's okay. Let me say that in a kind way.
Okay. Well, I think we covered a lot of the important issues, or maybe all the important issues for this very interesting case. So I'd like to thank Professor Zohar Goshen for speaking to us and sharing all of his knowledge and his research, not only for this case, but he has many years and decades of experience behind this, and is a real authority on corporate law, corporate transactions. So it was a real honor to have the opportunity to speak to you. I'm sure people are going to learn a lot from our session. And thank you for indulging me as I, maybe challenged a little bit on some of the issues, but that makes an interesting session.
Thank you so much. Thank you for having me. It was a great fun. Thank you so much.